The last case set for argument this morning is Cutlip versus City of Akron. It's case number 29319. Both parties are present to argue. Each will have 15 minutes for their argument. The appellant may reserve up to 5 minutes. Just let me know how much time you need so I can keep track, as well as the clock on the TV. We have read the briefs and are prepared to proceed if you are. Attorney Reese. Thank you.
Good morning.
Morning.
May it please the court, Christopher Reese for the appellant, in this case the City of Akron. Having read the briefs, the court is well aware that this case involves the examination and application of political subdivision immunity under Chapter 2744, and in particular the exception of 2744B2, which hereinafter I'll refer to as the B2 exception, just for brevity. And I want to say, almost to a lesser extent, but also valuable, was the argument of the application of the defenses in the case under 2744.03. In the court below, the city advanced 7 arguments in support of summary judgment. Before I address probably a select few of those, given the time limit, I want to first argue to the court, or point out to the court, something with regard to the B2 exception. The B2 exception is comprised of 3 components. The B2 exception has the performance of an act, negligence, and a proprietary function. Those are the 3 components that are embodied in the exception. One of the frustrations of political subdivision defense in the state and locally is that there seems to be a misconception among the plaintiff's bar, the trial courts, and on occasion the appellate courts, that the entire proprietary function exception here just hinges on finding a proprietary function. You know, I found the proprietary function, no immunity. We see those decisions a lot. You know, having found a proprietary function, we no longer have to address any of the other arguments because you have no immunity. I submit to the court that is incorrect. That is an incomplete analysis of the B2 exception. After the court or the plaintiff determines that a proprietary function is at issue, the added elements of the exception are now focusing on whether the plaintiff can point to the performance of an act, not an omission. That's a strict reading of the actual exception. It says the negligent performance, it says the performance of an act with respect to a proprietary function. It doesn't say the negligent omission with regard to a proprietary function, and that's critical because many of these cases, including this case, involve an underlying theory of omission, that the city didn't do something. The city didn't maintain this stall door. The city failed to detect some sort of condition with regard to the hinge. That's an omission case. The exception requires pointing to the performance of an act, and that's absent in this case. The plaintiff cannot point to a city person, a city employee, who went hands-on with this stall door and this hinge, and afterwards the injury occurred, where you can then examine that employee's performance to see if he negligently performed it. Did he act unreasonably? Things of that nature. So I submit to the court that what needs to become clear, and it has become clear in some of the other districts. I had a case out of the 7th District Court of Appeals from last year, Tangler, T-A-N-G-L-E-R, where it recognizes that proof of negligence is required in addition to just trying to locate and argue a proprietary function. The Puffenberger case out of the 8th District Court of Appeals that's cited in our brief says most courts will tell you there's 2 components, negligence and proprietary function. I submit to you, I believe, and the city believes, that there's 3 components. The performance of an act that is negligent with respect to a proprietary function. So I urge the court to examine on appeal, on this interlocutory appeal, issues well beyond whether or not this is just a proprietary function or not. That's not the beginning and the end of the immunity analysis in this case. So, do we have a proprietary function here? The city's position and their argument is that the maintenance of a public stadium is not a proprietary function. And the court is probably well aware that I've outlined that argument in the brief. It is a reading of the language that the legislature chose to put in the definitional sections of proprietary function. It used maintenance when it talked about the maintenance of a public cemetery. It talked about maintenance when it said the maintenance of a utility. It talked about maintenance in section D when it talked about the upkeep of a sewer system. But when you get to a public stadium, noticeably, blaringly absent is the word maintenance. It's only operation and control. You know, the legislature doesn't act willy-nilly here. They did not include the word maintenance. So, below, the city was faced with, and the trial court agreed, that maintenance is subsumed in the operation and control of a public stadium. The plaintiff's counsel, my colleague in this case, and the trial court are not left to make some decision that the legislature decided to not use the word, but leave everybody guessing as to whether maintenance is subsumed in the operation and control of a public stadium. Quite simply, the word was not used. This is a maintenance of a public stadium case. It is not a proprietary function. The maintenance of public grounds is a governmental function under the definition of the definitions of what's governmental functions. It defines the maintenance of public grounds. Therefore, the argument below and before this court that I urge the court to accept and validate is that what we have here is the maintenance of public grounds, a governmental function for which there is no exception to immunity. None of the 5 exceptions under O2B apply to negligent performance of acts with the governmental function. Governmental function almost has, in essence, blanket immunity. Now, the trial court, in ruling the opposite of that, said, well, if you accept the city's argument, the city will never be liable for maintenance of public grounds. It can't be that. Well, as I pointed out in the brief, you know, that there are proponents and opponents and arguments for and against immunity. You know, immunity is on the books. And the legislature saw fit to grant cities and political subdivisions immunity. You know, it's well beyond my pay grade to argue whether immunity, the concept of immunity is valid or not. But I can tell you that they have chosen a few areas where political subdivisions have this immunity, and the maintenance of public grounds, which is the stadium, public grounds, is a governmental function. So the analysis, in essence, should end right there.
So that maintenance at a public stadium would include seats?
I would say yes, it includes seats.
It would include the ball field itself? If the city's maintaining it, I don't know.
Boy, let me give that one some thought. That may be into the recreational activity definition is why I pause. You know, grounds used for recreational activity might be a bit different than grounds held open to the public. The ball field's not held open to the public. The restrooms and the seats and the concourse are held open to the public. So I think, at first blush, I may draw a distinction between maintenance of the field itself. We actually have a new case, ironically enough, but that may become an issue, a brand new case, but that being said, it's a case-by-case analysis, you know.
Well, yes, and I agree with you that it's very difficult with all these, because there's so many different spins on the facts. But I'm thinking of, you know, the Little League team that goes and walks across the field. You know, my kids did it many times when they were little. So that is opening up the field to the public.
I can tell you just out of memory, the operation, control, and maintenance of a ball field, a playground, a play field. So if we were talking about a ball field like a Little League ball field, but that's not your point, Judge. Your point is that they were doing a parade and they got injured. I think at that point, you'd have to argue it was public grounds. At that point, they held it open to the public. Obviously, maybe you would argue that the activity, the function is parades you wouldn't argue that it was maintenance of public grounds, that they were putting on some sort of a parade, which typically non-governmental people put on parades or something like that, but.
Let me jump to the definition again, because
Sure.
under B2, and I could be wrong, but isn't the language including but not limited to operation, control of a public stadium? And does maintenance, is that where maintenance might fall within a proprietary function?
I'm sorry, which definition is that, Judge?
I don't have it in front of me, but I thought 4402 B2 included the words something to the effect,
No, I think the entire
but
text.
not limited to, before the definition, before the examples.
No, I think that might be the maintenance and repair of certain grounds held open to the public, like courthouses and places of that nature. You know,
Now, I'm going to stop right now, just because you did not indicate you were going to
3 minutes.
3 minutes.
I'm
Okay, you're
sorry.
at 4:36 now, so I'll start the clock again.
I'm sorry. Not conceding that we have a proprietary function at issue here, then what happens is then the analysis turns to what I started, to go full circle to what I started at the beginning, which is an examination of whether or not the other components of the exception are met. I don't have time to go over all 4 or 5 of them that I believe are compelling, but I will tell you one of them that I think this case hinges on is notice. There is no duty owed to a person on a premises liability case against a political subdivision unless the political subdivision has prior actual or constructive notice of a defect. That is etched in stone. Below, the city tried to locate anybody who, if the city had notice of something that was the matter with one of these hinges, the city narrowed it down to the 4 critical people who were in the brief. Joey Arrieta, who was the manager of the Racers. Joey signed an affidavit, Ms. Arrieta signed an affidavit that she's just adamant, militant about this stadium. It's her baby. She monitors it during softball tournaments, before, after. This is the only women's bathroom. They go in there hourly almost and check to make sure there's toilet paper in the stalls and that the toilets are flushed. That necessarily requires someone to open and close those stall doors constantly. The cleaning up in between the events requires someone to constantly open and close the door. Ms. Arrieta testified as to how many softball tournaments there were just this year prior to this state softball tournament.
Council, you're at 3 minutes. I'm just letting you know now, total time left.
So I would submit to the court that the trial court did not give due just deliberation or opinion on notice. You'll notice at the end of its opinion it brushed off the notice requirement with all due respect by just merely saying there's a question of fact without addressing the city's arguments. I urge the court to delve deeper, do a deep dive into the notice argument in this case. Thank you.
All right, you'll have 2 minutes and 38 seconds for rebuttal. And council, you'll have, of course, 15 minutes for your argument.
Thank you, Your Honor. May it please the court and council, my name is Michelle Traska. I'm here representing the App.No's Angela and William Cutlip. The question here before this court is, in our assessment here, whether the city is acting as only a political subdivision can act, or is the city acting as a private organization would act. The maintenance and upkeep of a stadium is something that would be required of anyone who owns and runs a stadium, private or public. It would be very difficult to divorce that maintenance from the operation of the stadium. As Judge Teodosio alluded to, it is the preamble to 2741.01G2, which says that the proprietary functions of a political subdivision include, but are not limited to, those that are listed. Council here said that we are not to make a guess, put words in where the legislature did not. And I agree, but I don't think that we need to. I feel that the legislature knew that there was no way that they could enumerate every single thing that went into the operation and ownership of a public stadium. Therefore, they gave us those words, including, but not limited to, that we didn't need to specifically have maintenance in there. the council is correct in saying with the B2 exception, the way you should have done that, thank you. We do need to look to an act and to negligence and a proprietary function. We have the proprietary function here under 2744.01 G2E, the ownership, the operation, and control of the stadium. We do have an act. Now, even though the statute itself says specifically the word act and does not list omissions, the Ohio Supreme Court in Hill versus Urbana in 1997 said that 2744.02 B2 includes both acts and omissions. This court then, using that case in McCarskey in 1999, said that B2 has been extended by judicial fiat to include omissions as well as acts. And that has never been overturned by this court or by the Ohio Supreme Court. So acts or omissions. And here we have the failure of the maintenance crew, the failure of the city to attend to an issue. We have a public stadium that has one women's bathroom facility in the entire stadium with 3 stalls. There is a history of there being issues with doors falling off, doors missing, hardware missing. With the number of people rotating through here, players, coaches, referees, visitors, there's bound to be problems. And they have a history of problems. They have then no place to say that they are not on notice that there is an issue here, or that there is a notice issue here. Did they specifically know of this specific door at this specific moment? Maybe, maybe not. It would be very difficult to say. But we do know that they have had constructive notice. There is plenty of evidence to show that there is a pattern and a history of damage to these stall doors. Excuse me. So we have an act, we have negligence, we have a proprietary function. We have met the criteria for B2. Looking to 2744.03, there is no section that revives immunity for the city under that section. The court, the trial court, excuse me, agreed that we had met the criteria to establish exceptions under 2744.02, and that there was nothing under 2744.03 at this time that would renew immunity. And we're ready for us to proceed forward on the merits of the case. One more thing, we're looking at the council for the city is arguing that this is a governmental function and holds that this would be the end of the discussion. But this is not really a governmental function. Even if this were a grounds that were open to the public, that's not exactly what was going on here. This is the stadium. You have to pay an entrance to get in for these events. This was not something that anyone walking on the street could just walk into, come in, use the restroom, turn around and walk out. This was a restroom associated with the the proprietary function of owning and operating the stadium. So the governmental function label does not apply in this case.
Council, when you look at the statute, the G2 with what is a proprietary function, it is kind of, it does seem to indicate there's a difference between certain things. Like for instance, A says the operation of a hospital is a proprietary function. Then when it talks about township cemetery, municipal water supply system, or light, gas, power, whatever, it says maintenance, and then maintenance, destruction, operation
It does, the reading of it does tend to initially lead one in that direction, that is true. But as I said, looking at the preamble, we say that we see that the legislature knew that they could not list every single thing. So we have this included but not limited to language. Also, I think we need to look at the case law. There's a long history of case law saying that what we need to examine is whether or not the city was acting as only the political subdivision can act in things like running a sewer system, running a school district, running, a police department, running a court system. Or are they acting as any other private business owner would? And the running of a stadium is something that is analogous to something that a private business would do. And a private business could not get away with not maintaining their facilities. To allow the reading of 2744 to include the maintenance of a stadium, to not be subsumed by this operation and control of as a proprietary function, would leave anyone injured because of negligence or willful and wanton misconduct in a stadium no relief. There would be nowhere for them to go to seek relief for the injury that they
But as the city says, that's one of the main points of immunity,
It-
whether we like it or not.
This is true, this is true. But I don't think it was the legislature's intention to allow a city to go ahead and be free from acting irresponsibly when it comes to something as simple as maintenance of something that you already run.
In looking at the list of types of operations that a city could do under G2A, B, C, D, these are all a public cemetery, a utility, a sewer system. These aren't how we treat those things. These are lists of things. So couldn't that also include a public airport? I mean, it's a list of functions, a list of things that the city would operate, not the minutia about how those things are operated. It's just a list of things that the city could operate. Public airport, I guess that's what I'm looking at is.
I'm sorry, I'm trying to understand your question. Are you talking about the list of things that fall under government functions and proprietary functions?
Functions, yeah.
Okay.
The list of items that are under there aren't maintenance of those things. It's just a list of things that the proprietary function could be. Running a public cemetery, running a utility, running a sewer system. It's not maintaining it. These are different things that could be proprietary functions that are.
Yes, they are a list of things that if the state or the political subdivision were to undertake them, they would no longer be classified as a function of the government, but a proprietary function that is being run by a political subdivision.
I guess the city's point is, though, it says under A, the operation of a hospital, doesn't say operation and maintenance. Whereas under public cemetery, it does say design, construct, maintain, maintenance. Under, when it talks about utilities, it talks about maintenance. When you come down to public stadium, it just says operate and control, it doesn't say maintenance of it. So in D, they say maintenance, in C, they say maintenance, in B, they say maintenance concerning public cemeteries, utilities, and sewer systems. But boy, when you look at public stadiums, they had an opportunity, the legislature, to use maintenance, but they chose not to.
And they chose not to.
Sure.
And I don't know that anybody could get into the head of the legislature to figure out why they chose to single out public stadiums and hospitals from anything else that they did. But I think the 2 points are catch-all language at the beginning of that section, including but not limited to, is
What I
applicable here. And I also think that, like I stated, the case law that assesses this, going back many years over all the districts that we've seen, looks at in this function that the government, or this action that the government has chosen to, or the political subdivision, has chosen to undertake. Would what they're doing be considered something only a city can do? That would be a governmental function. This here is not a governmental function. It is a proprietary function. The running of a stadium, the ownership of another stadium, the control of the stadium, which has to include the upkeep of that stadium. Who's gonna wanna come to the stadium if you can't use the restroom facilities? Who's gonna wanna come if the grounds are overrun with weeds, or if the seats are all broken? And the purpose of the stadium as a proprietary function for the city is to increase revenue, increase visibility, thereby increasing revenue. That is something that is a proprietary function, and the maintenance goes hand in hand with that. If there are no further questions, thank you very much.
All right, thank you for your argument. Let's see, 2 minutes and 38 seconds for rebuttal.
Thank you. A couple of quick points in rebuttal. The Hill versus Urbana case, I urge the court to read that closely. That's an interesting situation. If you read the text of the Hill versus Urbana opinion, it does not say act or omission. It only says act. In the syllabus of the case, it says act or omission. It's always been political subdivision's position that whoever wrote that syllabus didn't go back and read the opinion and actually lift the text of the opinion and put it in the syllabus. And that issue was not before the Hill court. To the extent that's in the syllabus, it's dicta. The issue of act or omission was not before the Hill court. That's not what the Hill court stands for. And courts of appeals are beginning to understand that. Just this past April, in Bernard versus City of Cincinnati, obviously the first district, this court, or that court went on to say, just this spring, even if we were to find credible evidence in the record that certain omissions in the proprietary functions of the city could have caused the backup on the property, a proprietary inaction falls short of a negligent action. Courts of appeals are correcting what I believe, I don't even know what to call it, clerical mistake, somebody who wrote the syllabus in Hill versus Urbana. I urge this court to fall in line with the Bernard court and read the statute the way it was written, performance of an act. The city would be pleased if this case was decided on the issue that it was a governmental function. But I urge the court to, again, as I left off when I first started with the notice argument, you cannot surmise that there was notice in this case. There is no rebuttal from plaintiffs, the plaintiffs in this case, or the trial court, that Joey Arrieta, James Batten, Rick Johnson, or Jeff Morton, who all gave testimony in the court below, that they had no indication, no notice, no belief, no information that anything was wrong with one of those stall door hinges.
Weren't there records of the city that showed repairs?
There are records that are the focus of this case from April. This was in June. There was repair in April. If you read Jim Batten's affidavit, about 3 stores down, what do you call those blocks and the cement in between them had given away, and the doors were actually coming off the walls, I guess you would call them. And what was repaired was those were repaired to put the doors back up. What I'm getting at is it had nothing to do with the hinges, nothing whatsoever. Jim Batten.
Did the records show a general lack of maintenance or need for repair of the restrooms in a general sense that could be noticed to the city?
I would say no. The record does not contain any of that, and I can say that I think the affidavits in support of summary judgment below actually dispel that notion that nobody complained. Joey Arrieta would get every complaint that when something's wrong with this stadium, and she would immediately report that to Jim Batten, who would then get one of his maintenance people on it. There was no indication that there was any situation with regard to these bathroom stall doors. Not the bathrooms, the stall doors.
Sorry, counsel, your time is up.
Thank you very much. I urge the court to reverse the trial court and enter summary judgment in favor of the city. Thank you very much.
Thank you both for your presentation. The court will take this matter as well under advisement and issue a decision. Due course, the clerk, of course, will mail each of you a copy of the decision. On the day it's released, the opinions are also posted on the Supreme Court of Ohio's websites. The court will next convene on August 20th.